the critical Supreme Court decisions that are involved in this. Now, with the background I've been giving you this morning, you ought to see that what's been happening with the Supreme Court is crazy. Everson versus Wall, 1947. That was the beginning of the bad stuff. They used the 14th Amendment, the court did, which was used to ensure the civil rights of the freed slaves right after the Civil War. The 14th Amendment, they used it to apply the First Amendment to the states. This had never been done before. The Bill of Rights, then, is now being used to restrict the states. The Bill of Rights, if you read it, is restrictions on the federal government, not on the states. The Congress, the first Congress that passed the Bill of Rights, never intended for the states to be restricted. All of the powers not expressly delegated to the federal government are reserved to the states and to individual American citizens. Now here the court in 1947 totally violates the will of the American people because the Congress had before 1947 rejected 6 attempts. 6 times the Congress had rejected bills that were introduced that would apply the 14th Amendment, that would use the 14th Amendment to apply the First Amendment to the states. Now the First Amendment is the one that the court has used about this nonsense about the separation of church and state. The First Amendment has nothing to do with the separation of church and state. The First Amendment says, quote, Congress, so they're the only people that can violate it. A school kid can't violate the First Amendment. A school principal can't violate the First Amendment. A state official can't violate the First Amendment. Only the Congress of the United States can violate the First Amendment. All right? This is crazy what's going on today. To try to make the First Amendment apply to all these different groups and so forth is bogus. It says Congress shall make no law concerning the establishment of religion, nor prohibit the free exercise thereof. 2 clauses, the Establishment Clause and the Free Exercise Clause. All right? Now, it's crystal clear that when the court is using the 14th Amendment to apply this First Amendment to the states, saying that therefore state public schools cannot have religion or prayer or Bible reading in the public schools. It is totally flying in the face of the will of the American people. Not only do the polls tell us that something like 84% of the American public wants prayer back in public school, but they're flying in the face of 6 attempts on the Congress. 6 times the Congress said, no way can you use, shot them down 6 times. 1947, the court does this. Next case was Engel versus Vitale, 1962. This is the one that declared voluntary non-denominational prayer in schools to be unconstitutional. This is the one that took prayer out of public school. Now, folks, this is the first time in American history that religion was separated from education. Prior to 1962, we have 342 years of American history, back to 1620 when the Pilgrims arrived. For 342 years, never had any court in the United States ruled a school activity unconstitutional. For 342 years, circuit courts, appellate courts, the whole system, never had any court ruled a school activity like prayer or Bible reading unconstitutional for 342 years. Now, if it is so obvious that the First Amendment renders prayer and Bible reading unconstitutional, if you can get that out of the First Amendment, which is ludicrous, but if you could do it, how come it never showed up in any court cases for 342 years? This is insane. Education has now become the battleground of church and state. Abraham Lincoln said, the philosophy of the schoolroom in one generation will become the philosophy of the government in the next. Exactly right. The philosophy of the schoolroom in one generation will become the philosophy of the government in the next. Bill Clinton is a 1960s Flowers child. He was educated with all of the 60s humanistic philosophy. So why in the world should we be so surprised with what he's producing in Washington? He's just doing what he was taught. Wallace versus Jaffrey, 1984, that's when the Supreme Court struck down the one moment of silence idea. 1984. Now, they cited 200 cases in 1984. 200 cases to try to buttress their position. From before 1947, there were only 22. About 10% of the cases were before World War II, about the separation of church and state, or supposedly bad stuff like prayer and Bible reading in public school. They couldn't find anything. So what they did was they were citing themselves. All of the cases they were citing, 178 of them, were between 1947 and 1984. When the court had embarked on this craziness, so all they were doing was saying, oh, well, of course, this is perfectly legal to do because, 10 years ago we said, and they were quoting themselves. Now, this is totally bogus. You can't build court precedent on what you said, last week. That doesn't work. Now, the Supreme Court these days tries to make the Founding Fathers speak for this craziness. They try to make Madison and Jefferson speak for it. Let's go back and see what Madison and Jefferson actually said about the Supreme Court. What did the Founding Fathers, what was their attitude about the Supreme Court? This will blow your mind. Listen to this. Thomas Jefferson, letter to Samuel Miller, 1808. I consider the government of the United States as prohibited by the Constitution from meddling with religious institutions, their doctrines, discipline, or exercises. This results not only from the provision that no law shall be made respecting an establishment or free exercise of religion, quoting the First Amendment, but from that also which reserves to the states the powers not delegated to the general government. That's the 10th Amendment. It must then rest with the states as far as it can with any human authority. What's Jefferson telling us? See, the federal government has no business messing with the schools. They are the responsibility of the states, the various states. Thomas Jefferson to Abigail Adams, 1804. The opinion which gives the judges the right to decide what laws are constitutional and what are not only for themselves and their own sphere of action, but for the legislature and the executive also in their spheres, would make the judiciary a despotic branch. Now, do you hear what Jefferson is saying? He's saying the Supreme Court of the United States has no right to tell the executive branch, the president, or the Congress that what they've done is unconstitutional. They have no right to do that, and they do it all the time. And as far as the Founding Fathers are concerned, this is not constitutional. We have a system of 3 equal branches of the federal government. The Supreme Court has no right to tell one of the other 2 branches they can't do what they've done. American government doesn't function the way the Constitution says it's supposed to anymore. And it's clearly against the intention of the Founding Fathers. Jefferson to William Jarvis, 1820. You seem to consider the judges as the ultimate arbiters of all constitutional questions. And I want to tell you, the Supreme Court justices in the last 30 years have claimed this publicly over and over. Well, it's up to us to decide. Hogwash. Jefferson said, this guy William Jarvis wrote Jefferson and said that same kind of thing to him. This is Jefferson's response. You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed. And one which would place us under the despotism of an oligarchy. As, 9 men. He goes on to say, the germ of dissolution of our federal government is in the federal judiciary. An irresponsible body working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped from the states and the judges as the ultimate arbiters of all constitutional questions. This is a very dangerous doctrine indeed. James Madison. As the courts are generally the last in making the decision on laws, it results to them by refusing or not refusing to execute a law to stamp it with its final character. This makes the Judiciary Department paramount, in fact, to the legislature, which was never intended and can never be proper. The framers never intended the Constitution to be interpreted the way the court has done recently. Here's a quote from George Washington about the separation of church and state. Listen to this. If I could ever have entertained the slightest apprehension that the Constitution framed by the convention where I had the honor to preside might possibly endanger the religious rights of any ecclesiastical society, I certainly never would have placed my signature on it. Congress, 1853, the Senate Judiciary Committee made the following statement. Congress of the United States, 1853. Had the people during the Revolution had a suspicion of any attempt to war against Christianity, that revolution would have been strangled in its cradle. At the time of the adoption of the Constitution and the amendments, the universal sentiment was that Christianity should be encouraged, not any one sect. Now this will blow your mind. In the 1962 Engel versus Vitale decision that removed prayer, Bible reading from public school, in that decision there were no prior cases cited whatsoever. Not one. Because there were none to come up with. That Supreme Court, folks, had not one justice with any prior judicial experience. I'm telling you, not one of those 9 Supreme Court justices had ever been a judge. Not one. Now, how in heaven's name can we expect men who had never even been a judge to understand the Constitution of the United States? Those justices were political judges, not constitutional judges. As Edwin S. Corwin pointed out in the Constitution of the United States, this court, which during its tenure was able to completely remove God from education by a series of horrific decisions, did not have a single judge with any prior judicial experience. Despite the oath the justices take when entering office, the court did not intend to follow the original intent and uphold the Constitution. In Everson versus Wall, 1947, the Supreme Court said, quote, neither a state, listen to this insanity, neither a state nor the federal government can pass laws which aid one religion, aid all religions, or prefer one religion over another. But the earlier courts obviously preferred the Christian faith. Runkle versus Weinmiller, 1799. Quote, by our form of government, the Christian religion is the established religion, and all sects and denominations of Christians are placed upon the same equal footing. They were deliberately refusing to follow prior court decisions that clearly indicate the Christian faith is the basis for American life. Stone versus Graham, 1980. This was the case that removed the 10 Commandments from the classroom wall. Said it was illegal to put the 10 Commandments up on the schoolroom wall anymore. Stone versus Graham, 1980. The court said, quote, that if the 10 Commandments were posted up on the wall, the effect would be, quote, this will break your heart. The effect would be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. And this is not a permissible state objective under the First Amendment. James Madison, the chief architect of that very amendment, said, we have staked the whole of our political institutions on the capacity of mankind to govern themselves according to the 10 Commandments. And the Supreme Court says, obeying the 10 Commandments is not a permissible state objective. And Madison said the whole thing is based on the 10 Commandments. I mean, this is a total rejection of everything America was founded on. Proof that the First Amendment was never intended to separate Christianity from public policy is revealed very clearly by the fact that on the very same day that the Congress approved the First Amendment, they also approved the Northwest Ordinance. which established the government, the beginnings of government, for the territories north and west of the Ohio River, which would be the states of Ohio, Illinois, Michigan, Indiana, and so forth. All right? The third clause of the Northwest Ordinance says, religion, morality, and knowledge being essential for the happiness of mankind, schools and the means of education shall be forever encouraged. The Congress of the United States is saying the schools are to encourage religion and morality as well as knowledge. Now, folks, the Founding Fathers would have had to be totally schizophrenic. I mean, totally schizoid, okay, to have passed that on the same day they passed the First Amendment. If in their minds the First Amendment had been intended to use to separate church and state, they never would have passed that Northwest Ordinance with that third clause that says the schools are to encourage religion and morality. I mean, this doesn't make any sense. This very same day. Very same day.